Ready, start. In this appeal filed under Section 384 of the Indian Succession Act 1925, the petitioner, who is the sole legal heir and successor of deceased P.K. Himavati, challenges the order dated 14/10/7005 passed by the subordinate judge Ernakulam in succession OP 20/05. The said original petition was filed under Sections 371 and 372 of the Indian Succession Act, praying for a succession certificate in respect of certain bank deposits totaling to rupees 1.95 lakh and in respect of 6 cents of landed property with a building thereon, even though the court below, as per the impugned order, held that the appellant is the sole legal heir of the said Himavati, who died intestate on 29/1/2004, and allowed the original petition granting a succession certificate in respect of the bank deposits which were detailed in Schedule 1 of the original petition. That could disallow relief in respect of the immovable property described in Schedule to the said original petition. It is agreed by that part of the impugned order which has declined to grant a succession certificate in respect of the movable property that the appellant has preferred this appeal panel. We heard ADV. Sri P.K. Ibrahim, the learned counsel appearing for the appellant assailing the impugned order. The learned counsel for the appellant submitted that Section 30 and 192 of the Indian Succession Act will indicate that a succession certificate can be granted in respect of immovable properties as well. We are afraid that we find ourselves unable to agree with the above submissions. The fact that the appellant is the sole legal heir and successor of P.K. Himavati, who died intestate on 29/01/2004, is beyond the pale of controversy. Exhibit A2 is the death certificate pertaining to Himavati. Her husband Karunakaram had predeceased her as evidenced by Exhibit A1, death certificate Part X of the Indian Succession Act 1925, within bracket hereinafter referred to as the Act for short, starting from Sections 370 to 390, deal with succession certificate. Subsection 1 of Section 370 read as follows: 370, restriction on grant of certificates under this part, within bracket 1. A succession certificate, within bracket hereinafter in this part referred to as a certificate, shall not be granted under this part with respect to any debt or security to which a right is required by Section 212 or Section 213 to be established by letters of administration or probate, providing that nothing contained in this section shall be deemed to prevent the grant of a certificate to any person claiming to be entitled to the effects of a deceased Indian Christian or to any part thereof with respect to any debt or security, by reason that a right thereto can be established by letters of administration under this Act. A reading of Section 370 and 372 of the Act, particularly clause within bracket A of subsection within bracket 1 of Section 372 of the Act, will show that a succession certificate can be applied for only in respect of debts and securities. The expiration date has not been defined under the Act. The said expiration has not been defined under the General Clauses Act as well. If so, one has to go by the ordinary meaning of the said expiration. A debt means any pecuniary liability, whether payable in presently or in future to another in return of money, services, goods, or any other obligation. A debt is also property in the form of a chose in action and is heritable and assignable as understood in law. In the case of securities, subsection 2 of Section 370 of the Act enumerates the various securities envisaged by the section. They are as under within bracket small a, any promissory note, debenture, stock, or other security of the central government or of a state government, within bracket small b, any bond, debenture, or annuity charged by Act of Parliament within bracket of the United Kingdom on the revenues of India, within bracket C, any stock or debenture of or share in a company or other incorporated institution, within bracket D, any debenture or other securities for money issued by or on behalf of a local authority, within bracket small e, any other security which the state government may by notification in the official gazette declare to be a security for the purpose of this part. The fact that a succession certificate can be issued only in respect of a debt or security is further reinforced from the wording of subsection within bracket 3 of Section Section 372, which clarifies that an application for a succession certificate can be made in respect of any date or dates due to deceased creditor or in respect of portions thereof. Section 376 of the Act makes provision for the grant of extension of succession certificate to any additional date or security. Section 377 of the Act says that the certificates as well as extension of certificates shall be in the forms set forth in Schedule 5 III of the Act. The said forms reads as follows.